All right, this is case number 19-177327. This is West Michigan Debt Collections Incorporated versus Anastasia Baskins. The matter is before the court on the filing of a subpoena regarding this matter. Record should reflect in this matter that judgment was entered by default. That judgment was entered on the 12th of September 2022. The amount of the judgment is $4,470.38. Well, strike that. The total judgment is $12,245.81. Your appearance for West Michigan Debt Collections, please. We have our audio, right? Counsel for West Michigan Debt Collections. Do I have Anastasia Baskins on this Zoom? All right, and neither have checked in regarding this matter. The matter is set on for 9:30 a.m. The subpoena in this matter be dismissed where the petitioner has not appeared before this court as ordered to do so. The court now calls case number 22-184871. This is Michigan CRNA Staffing LLC versus City of Detroit. The matters before the court set on for a pretrial conference date. Your appearance for the plaintiff regarding this matter. Do I have the parties on? Just one moment here. CRNA's Staffing Solutions LLC versus City of Detroit. Your appearance, please.
Yeah. Good morning, Your Honor. Philip Hiltner, P77913 for defendant. And
right, to you, do I have someone for Michigan CRNA's Staffing Incorporated? If you're here, please say something at this time. All right, counsel, any update that you can give me? Have you spoken with anybody recently regarding this matter?
Yes, Your Honor. The case is actually settled, so I'm not too surprised. No one's here from plaintiff's counsel's office. We just need to submit the order, but everything else is already taken care of.
All right, sounds good. Counsel, is this something that's requiring city council approval, or have you been able to get resolved about the details?
I don't remember off the top of my head if we needed it, but either way, we had the check taken care of. So if we needed city council approval, it's already done. So.
All right, sounds good. Sounds good. Would you like for me to issue? I'm sure you received one of the orders that I issue in these kind of cases, dismissing it and giving an opportunity for reinstatement if something falls apart, making it final once payment is dispersed. I can send out such an order. You want me to stand down and let you do what you have to do?
Normally that order would be great. I think our order of dismissal is already prepared and probably on its way to the court. So.
All right, sounds good. I appreciate your update regarding this matter, and it's unfortunate that you forgot the details, but I know that it's all of the money you're spending during this season that's caused you to forget the details of this case.
That's right.
All the best to you. Happy holiday season, sir.
Thank you. Thank you, Your Honor. You too.
All right, the court now calls case number 22-190879. This is Protective Insurance Company versus Rakina, last name Dodell. The matter is before the court. I did set it on for a status conference on today's date. The record should reflect that the complaint in this matter alleges damages of $7,436.34. It looks like this is related to a claim regarding repairs that were made and a subrogation claim. All right, for Protective Insurance Company, your appearance at this time.
Yeah, good morning, Your Honor. May I please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
All right, thank you, counsel, and good morning to you, sir. I'm looking now for Dodell, Rakina, and or Gregory Dodell. If you're on the Zoom, please say something at this time. I'm looking for the last name is Dodell. Persons purportedly living in the city of Redford on Garfield Street. If you're in this Zoom, please say something at this time. Counsel, have you had any contact with the defendants regarding this matter other than the answer that the court received in this regard?
Judge, I actually see an individual named Rakina Dowdell in the Zoom room. She is one of the people that has Zoomed. I just don't see her responding to your inquiry.
Yeah, she's not. Her audio is not connected.
Okay.
All right. So my clerk is going to send her a chat. She probably needs to hang up and call right back in, Madam Clerk. Just let her know her audio is not connected. And Mr. Cox, on a very busy day, I'm sure for you, I'm going to ask you to give me a few moments. I'll come right back to you, Madam Sir.
Sounds good, Judge.
The court now calls case number 22191224. This is State Farm Fire and Casualty versus JJ House Company LLC. The matter is set before the court regarding the court previously adjourned this matter and set the case over for pretrial. Your appearance regarding this matter for plaintiff? Do I have someone for a defendant in this matter? All right,
Yes.
now what?
Oh, I'm sorry, Your Honor. They both was here. There should be something.
Yeah. I do see the parties have stipulated to adjourn the pretrial conference for 45 days. I don't typically allow such stipulation in such orders. The court has not set up a scheduling order in this case, which is part of the concern that I have. The parties did indicate at the last hearing that they were likely to have this matter settled and resolved. And that's why the court delayed issuing a scheduling order. I'm going to conclude that they are likely trying to get it resolved, and I'll go ahead under these circumstances and allow for a continuance of this matter. I do have it a note that the plaintiff is conducting an audit and will not be, that audit will not be timely completed prior to this particular pretrial conference. So given that there is a process that is on the way, and this does not seem to be an unreasonable request for delay, the court will grant the stipulated petition in this matter and will set the matter over, giving it a court date February 21st, and that's going to be at 9:30 a.m. February 21st, 9:30 a.m. So ordered. That's that one. We can put the date in the order. All right, do we get any information on what, am I able to reach Ms. Dodell?
Yes.
There? All right,
Yes.
good morning.
Good morning.
On the record. Just one moment. Yes, I hear you now. I'm back on the record regarding 0879. That is Protective Insurance Company versus Rakina and Gregory Dodell. And Ms. Dodell is present with us this morning. Attorney Cox represents the plaintiff, and he has entered his appearance as well. I've set this on as for a scheduling order where I received the defendant's answer to the complaint. In her answer to the complaint, she says the insurance company paid the plaintiff. She also says that the information is inaccurate. Counsel, have the two of you been able to speak at all about this to try and see if there's any room for resolution?
Not yet, Your Honor. I will note that the procedural documents that I possess seem a little backwards. We show that Gregory Dowdell was served on November 6, 2022. He's not filed an answer or appeared here today. On the other hand, Ms. Rakina Dowdell, we don't show service at all, but she did file an answer, and she has appeared here today. I guess Ms. Dowdell has maybe availed herself to the jurisdiction of the court by filing an answer despite not having been served. And then Gregory Dowdell, who I think is now, by my calculations, in default. That all being said, Judge, I'd be happy to speak to Ms. Dowdell in a breakout room to find out a bit more about what her defense is and what we might do to resolve the matter. But it is sort of an odd thing. It looks backwards to me, and I'm not sure I can explain to court why it is.
Right. Mr. Odell, are you, I know that when you signed off on your answer, you did not include Mr. Gregory Dowdell. Are the two of you working on this matter together, or are you advancing the call separately?
I'm working, it was my vehicle. And I talked to my insurance company and they like, you're liable. He was not in the car, So they told me, they talked to them already about this matter and denied them because they don't believe that car hit a truck and caused that kind of damage. And their insurance company paid their truck. Their insurance company paid for the damages for their truck.
All right. Well, the insurance company that repaired the truck, they are saying that they are entitled to get reimbursed for what they paid because somebody else is responsible. That's what the case is about. My question to you is, where is Mr. Dowdell? Have you spoken with him on this?
He's working. I've been trying to contact him. I don't know exactly where he's at. He does not live with me. That's my son.
So the situation here is that there's no documentation that you've been served, but you did file an answer. And the question is whether or not you are actually submitting to the jurisdiction of the court. They haven't served any papers on you yet. By submitting to the jurisdiction of the court, that means that you are waiving the requirement that documents be served on you, and that you are.
It's my vehicle that's involved. It was my vehicle.
All right, but do you understand what I'm saying to you?
Yes, but see, they keep saying my son. My son said that they were somewhere and somebody got a hold.
Let me stop you that we not waste time. So Mr. Gregory Dowdell is your son, correct?
Correct.
All right, and so his name was on this vehicle at the time that whatever occurred happened. Is that correct?
No.
Okay, he was the operator of the vehicle?
No.
So they sued him, and that's what I'm trying to get at. Was he driving the vehicle? Was he a co-owner? Did he sign off on the debt or anything? What was it?
No.
Judge, our allegation is that he was the driver. He's listed as the driver on the police report.
Oh, okay. All right, that's what does that. Okay. So I'm going to put you all in a breakout room to talk about the perimeters of this and see if there's a way to get some understanding and perhaps get a resolution. If not, I'm going to bring you back in and we'll set up a schedule on the case to try and figure out where to go forward. I do see a problem that could turn very significant, but it sounds to me that Ms. Dowdell is saying that she wants to go forward on this and she does not want her son involved in it. She may be able to make that first decision, but she may not be able to elect the second decision, because what has happened is that your son has been served, and by him not being here, he could be held in default and a judgment could be entered against him. So he would have to respond to the complaint, even if he feels like he's done nothing wrong. He would need to respond to the complaint so that a default is not entered against him. So I'm going to put you in a breakout room, and then I'll talk to the two of you on the other side of the discussion that you may have. So there's your notification, ma'am. Just click in, and you'll be able to talk to Mr. Cox regarding this matter. And I'll come back to your matter as you return to the court. All right. So go ahead and click in. All right. This is case number 22196074. This is Diane Hunter and Gregory Hunter versus Taisha Marie Lee. The matter is set for a scheduling conference on today's date. The court having received an answer to the complaint. The complaint alleges damages of $12,525. It looks like this is allegations that are associated with a claimed holdover tenancy. Of course, the defendant has filed an answer saying the dwelling was not stable to live in, and that therefore the premises that they should not be assessed any obligations because of the premises being unfit to occupy. All right, do I have Hunter and Hunter or counsel for Hunter and Hunter? If so, say something now. I'm looking for
Gregory Hunter.
And
All right,
Diane
thank you,
Hunter.
Thank you, Mr. Hunter, and thank you, Mrs. Hunter. I see the two of you there regarding this matter. I'm looking for Ms. Lee now. Say your name for the record for me, Ms. Lee, please. Ms. Lee, go ahead and unmute yourself. Ms. Lee, you'll need to unmute yourself for me to hear you. So go ahead and hit *6 or take yourself off mute, ma'am. You're on mute, so I can't hear you.
Good morning. Can you hear me now?
I hear you now, ma'am. Give me your name.
Taisha Lee.
All right, thank you, Ms. Lee, and good morning. Good morning to you, ma'am. All right, so this looks like a landlord-tenant real estate lease that the parties entered into, and it looks like there is a claim that the property was unfit to live in, and that therefore the defendant is claiming that she does not have any obligation in this regard. So let me ask you, Mr. Hunter. It looks
It's
like
a
you
cold
filed
blue. It's a cold blue. Oh my God.
Miss Lee, are you at work? Are you?
Yeah, I'm in the hospital. I wish this could be adjourned because
Are you? Listen to me. Listen to me. Are you in the midst of some cold blue or something now?
yes, we are.
All right. So it doesn't seem like to me that the two of you are going to be able to reach any kind of agreement regarding this matter, and it may end up in trial. The procedures that rest before that is for the court to set up a period of discovery for the exchange of information, so that the parties will have an opportunity to request of the respectively under law the right to receive any information that they plan on at trial. So what I'm going to do is I'm going to set a schedule in this case, and that's going to result in the court setting this for a pretrial conference. That pretrial conference date is going to be the 21st of February, 21st of February, and that's going to be at 9:45 a.m. You'll get a notice of that pretrial conference of February 21st, 9:45 a.m. You'll get that notice in the mail. You'll also get a scheduling order. That scheduling order will allow you to discover information. If you request information from the other party that relates to this case, they've got to turn it over to you. And it will also allow you to file motions, a request that the court take some action and to have your motion heard on the 21st of February. That will be explained to you in the order that you're going to receive from the court. So you're going to receive an order from me giving you a new court date. That date's the 21st of February, and also telling you that you have the right to discover information from the opposing party up and through that date, and then come back and see me, and we'll deal with the case further from that point. So I wish the two of you, I wish both sides well in this matter. You'll receive my order in the mail in the next few days. Good day to both of you.
Okay, thank you. It's here,
Good day,
down
good day.
here. Okay, thank you.
Understood.
All right, thank you, good sir. Good day. All right, this is case number 21-168-936. This is Waste Management of Michigan Incorporated versus Tequila Industria Familia LLC. The matter is before the court. Looks like on motion to enforce judgment. All right, your appearance at this time, if I have counsel for Waste Management of Michigan, please.
Good morning, Your Honor. John Mueller appearing on behalf of the plaintiff, P number 35413.
All right, thank you, Mr. Mueller, and good morning to you, sir. I'm looking for someone regarding Familia that might be on the Zoom. Say something if you're on the other side here. All right, so counsel, tell me what is it that you're requesting in this regard?
Your Honor, there seem to be a couple of issues on the file. I think the court set up the motion. I don't recall filing a motion, but it did request a subpoena. And I've tried to get a garnishment issued against the individual defendant. I've received a couple notices from the court that one, the case was dismissed, which I have a judgment, so it can't be. And number two, that I don't have a judgment on defendant two.
Mr. Mueller, it's your device. Something is cloudy about your device. So if you could see if you could straighten that out a little bit. And I am familiar with some of what you are pointing out. So what I had is, if I can put it on the record, I entered an order of dismissal on this case on the 13th of September 22, where neither party appeared for a hearing on that date. So that's where the dismissal comes from. It looks like that dismissal was secondary to a scheduled hearing. And let me see what the nature of that hearing was. I'm not sure what the nature of that hearing might have been, but that's where I get the dismissal. I do note that there was let's see, looks like there was a judgment. Yeah, there was a judgment entered February the 9th of 2022 in this matter. And then I do see where there was an application or a subpoena that was filed subsequent to that time. Then after the subpoena was filed, that's where the dismissal was entered when neither party appeared. So it seems that there's something wrong about that.
Right.
So something's off about that kind of history, because even if there was not an appearance on the subpoena, that would not result in the case being dismissed. But my only note on that says that neither party appeared. So you're asking, what are you asking the court to do in this regard?
Two things, Your Honor, and I'll try to speak up. Hopefully you can hear me. One, that the dismissal be set aside because I think it was just the court noting that we didn't appear for the creditor's exam. I think that's what the court was trying to note. But the creditor's exam was at my office anyway, so I think there's some confusion all the way around on the file. So I would ask that dismissal be set aside because obviously we were already in post-judgment. Number two, somebody at the court doesn't think I have I don't think it's you, it was a clerk, doesn't think I have a judgment on defendant two, but if you see the judgment, it's on all parties. So I need to make sure the court record's corrected on that because I was not allowed to issue a garnishment on the individual. They didn't think I had a judgment against him.
Well, I do see, let's see. 1 second, sir. The record should in fact reflect that the judgment that was entered is as to all of the parties where there was a complaint filed. I guess the only issue would be if there was service regarding each of those persons, and looking at the proof of service documents. I do see service with respect to Kira Nestura, Familia LLC, and I also see service as to George Canchola, it appears. So if those persons are the persons, or that is the individual that you're talking about, I do see the proof of service document in that regard. So there's a judgment against those respective parties. So I don't know where that information, or unless somebody's reading something wrong. I see the proof of service and I see the entry of the judgment as to those persons. So
Do you-
in the first instance, I will set aside the dismissal, and the same will be held for naught, as that dismissal should not have been entered. It looks like while this was set up to be heard in front of this court, that the actual subpoena had the location for the defendant to appear at an address in Birmingham, Michigan on Woodward. So that the dismissal should not have been entered in this matter. And that dismissal will be set aside and held for naught. Anything else at this time, Counsel?
Yes, one more thing, Your Honor. As to that judgment issue, there was an actual letter. I'm wondering if you see it in the court file dated April 21st, 2022 from the court to me.
A letter directed to you or a letter from you?
No, to me from the court, from Tamika Harris, the lead cashier. She sent it to me on April 21st. And the only reason why I bring that up is that's the letter where it says I can't have the garnishment because I don't have a judgment on defendant 2. I'm just wondering if you see that letter. Because I'm gonna have to try and correct that. Somebody there doesn't think I have a judgment.
No, I don't see where that letter populated to the court's file.
Okay.
But I am absolutely certain that you received such a letter. I don't know how you might go about addressing that issue. All I can do is give confirmation, certainly, that there is proof of service as to the defendants in this matter, and
Okay.
that the judgment applies to all defendants. That is in fact the case.
Thank you. Thank you, Judge.
All right. So I'll sign an order consistent with my determination regarding this matter on today's day. All right. Thank you, counsel.
Thank you. Have a good holiday.
You too. Everyone. All right, the court does now call case number 21-172-543. This is First Portfolio Ventures 1 LLC versus Michelle Renee White. The matter is before the court on a motion to read this matter. The record should reflect that the matter was dismissed on the 29th of July. It has 29, but clearly that is not the year. So it would have been July 29th of 22. And there is a request now to reinstate the case. And actually, I saw where there was I think that motion was read in a motion to reinstate and allow the parties to enter into a consent order. All right, so let me get your appearance now for the plaintiff for First Portfolio.
Good morning, Your Honor. Laurie Frank, P 43509, appearing for the plaintiff.
All right, thank you, Ms. Frank, and good morning to you. I'm looking for Michelle White or Michelle Parks. If you
Yes,
want to
I'm here.
Say something.
I'm here.
All right, and what's your name? Tell me your name, please.
Michelle Renee White.
All right, thank you, Ms. White, and good morning to you, because I know they have also known as Clark, so I wanted to hear it from you. Thank you, Ms. White, good morning.
You're
All
welcome.
right, so, Madam Council, what's going on here?
Yeah, Your Honor, as you alluded to, this has a little bit of a tortured procedural history. We did enter into a consent order of dismissal with leave to reinstate. Ms. White made payments from May to August of 2022. And then after we filed the motion, we received a payment in December. So what I'd like to do is this, Your Honor. I guess it's kind of the one bite at the apple rule. And as long as Ms. White makes an affirmative states on the record she will continue to make payments, we will withdraw our motion.
All right, so Ms. White, you understand what's going on here, correct, ma'am?
Yes, I just was a little confused and I tried to get some understanding from the court when I got the letter of dismissal because I had been making my payments. And then when I got the dismissal, I stopped and then I started back after I had some correspondence with Ms. Frank. I just wanted to make sure that I was doing the right thing.
Yeah, that makes sense. So the dismissal is a way of the case not being reported as some type of judgment against you on some type of report. That's the nature of that. But with the parties having an understanding that they have a payment arrangement, and as long as that payment arrangement is in place, then the case remains dismissed and not get reinstated, with the idea that once it's paid off, then all of this goes away. That's the goal. So,
Okay, I understand now. So I will continue to make my payments. That's no problem. Because like I said, I was paying, but I wasn't sure as to what and another thing, the number that's on the court paper, the young lady that answers that phone is so rude. And I've tried to get resolution to her, but I've never got a call back from the court. So that's why, it took a while for me to try to get an understanding of what was going on.
now, are you saying that someone you called at the court was rude?
Yes, she actually hung up on me a couple of times. Just, she's just like, it's dismissed. I don't know what to tell you. And then slam the phone down. And I went through this several times, and I guess you have caller ID. So then she stopped even answering my calls.
All right. And how long ago did you make those calls?
I made them after I got the dismissal letter. I called maybe about 4 or 5 times, just trying to get a clear understanding, even called like a supervisor and left a message, but I never got an answer back from anybody.
Let me first apologize on behalf of the court. Nobody should be rude to you. One of the challenges that persons here have is that they can't give out legal advice. And so if the case is dismissed and you want to know what the what happens next, the only thing that they can really tell you is that the case is dismissed. And that's why when there are a number of reasons that cases get dismissed. The agreement between the parties, the agreement between the parties is something that has to be hammered out with the parties. The clerk would not be able to get into that with you. And if they tell you that and you call back, they tell you the same thing, and you call back, they're gonna tell you the same thing. They still shouldn't hang up, but that could be a little bit challenging. What you needed was you needed an answer that really arose out of being able to talk with Ms. White and figure out what the nature of the agreement was. And I think we've achieved that. But again, I certainly apologize on behalf of the court, because nobody should be rude to you. And as it relates to my staff, I try to protect that as much as I possibly can, because we get a lot of calls, there's a lot of paperwork, but at the same, and then they have limitations. I can talk to you about stuff that they can't talk to you about, So they tell you, so and so and so and so, and you say, well, what about this? They say, ma'am, that's all I can tell you. That's all I know. That can be frustrating, but it's frustratingly true. That's as far as they can go, And so sometimes you just have to get back in court to get down to the bottom line as to what really occurred. And so I think everybody's on the same page. I will allow the withdrawal motion at this time, with the understanding that the payments will continue. And I wish all parties well. Good day to you.
Okay, thank you.
Happy holidays, Your Honor, and Ms. White.
Happy holidays.
Thank you.
Thank you.
Same to you. Okay, bye-bye.
This is case number 22-178326. This is Alrada Bakery LLC versus Eastbourne Partners LLC and Trinity Construction LLC. Welcome back in your appearance at this time for plaintiff.
Your Honor, Mohammed Zahir, P number 5, 2020, appearing for the plaintiff.
All right, good morning to you, counsel. And for the defendant in this matter, your appearance at this time, counsel.
Good morning, Your Honor. Aaron Cox, P 69346, appearing on behalf of the defendant Eastbourne Partners LLC.
All right, thank you, Mr. Cox, and good morning to you as well. And so, gentlemen, during this wonderful, excellent season of celebration, what are you fighting about?
Your Honor, today is the date and time set for defendant's motion for summary disposition. If the court would like, I can proceed.
And counsel, you did receive the motion for summary disposition, Mr. Zahir, sir?
Yes, Your Honor.
All right. Counsel, you may proceed with regard to your motion at this time.
Thank you, Your Honor. Judge, as we set forth in the motion, the plaintiff in this case has filed a 3-count complaint, breach of contract, fraud, and conversion. And while there are 3 counts, as is somewhat customary in legal proceedings, they all arise out of the same factual allegation. And that allegation is that my client withdrew from the plaintiff's bank account a payment. And the plaintiff's assertion is that that somehow is a breach of contract, fraud, and or conversion of those funds. It's not. It's very clearly not. And this court.
That's conspiracy as well, right?
Yes, Judge. There is a conspiracy count as well. Yep.
Go ahead, Mr. Cox.
It's very clear it's not, and this court has the authority pursuant to NCR 2.116 C8 and C10 to dismiss all of these claims against my client. I'll briefly summarize the basis for that, Judge. First of all, this is a commercial landlord-tenant arrangement.
Let me stop you for just a moment, Mr. Cox. Is our sound? Where is our sound? Because I'm not hearing you as clear. Let me see if it's on our end. Okay.
But I can try to get closer to my microphone as well, if that helps.
That's better. That's much better, Mr. Cox. Go ahead, sir.
So Judge, this is a commercial landlord-tenant arrangement. The defendant, Eastbourne Partners, is the landlord. The plaintiff is the tenant. They signed a written lease agreement for that relationship. Included in that written lease agreement is an addendum, essentially. That's Exhibit 4 to our motion. That's an ACH authorization form. And that is the form by which Alrada Bakery expressly authorized my client to withdraw from their bank account, and I'm quoting from that document now, all outstanding amounts owed on the rental account will be drafted from the authorized bank account. That ACH authorization remains in effect until revoked. What took place here was that the plaintiff went in and they did a number of alterations and repairs to the property that caused damage, specifically to the roof. My client had to go in and then pay to have the roof repaired and then charged Alrada Bakery back the expenses for those repairs. The expenses for those repairs were $6,000. We've attached to our motion documentary evidence, including an affidavit from Christina Rice, that expressly says these are the amounts that were incurred. This was the repair that was done. This was the amount that was paid, including a canceled check. Pursuant to the lease, my client had the express authority to charge those amounts back to the plaintiff in this case, which they did. And when those amounts became due and unpaid by Alrada Bakery, pursuant to the lease and pursuant to the ACH authorization, my client withdrew those amounts in order to satisfy the outstanding debt. So that is the factual background of where we're at. Now, they have filed, as we've already discussed, 4 separate counts.
Mr. Cox, and I don't want you to lose your train of thought, but before you go further, let me ask you, are you prepared to, and I believe in the motion that was set forth that all of the predicates for the ACH withdrawal were satisfied pursuant to the terms of the lease? Because of course, this was not just a lease payment that was withdrawn, but this was extraordinary issues that arose by virtue of repairs that had to be made. So as a predicate to withdrawing, to making the withdrawal, are you indicating, and I believe I saw in the motion that you indicated that all those predicates were taken care of, that notice was given to the to the plaintiff on outstanding obligations, that there was not a colorable dispute that was raised as it relates to those obligations, and that therefore the ACH withdrawal was made. That about the size of it before we move on to the next part of this?
That is, Your Honor, and the lease expressly authorizes my client to place those amounts onto the account, even without notice under certain circumstances like this, where they had to go in and do the repairs. But yes, my client certainly satisfied its obligations under the lease before placing these amounts, provided notice to Alrata, and withdrew them. So again, back to the claims that have been levied, right? Mind you, the plaintiff has asserted in count one a breach of contract. As we pointed out, as a C8 basis, they failed to state a claim for the very reason that you just articulated. Section 1304 of the lease and Exhibit 3 specifically says that before the landlord can be found in default, they would have had to have sent a notice to the landlord with an opportunity to cure in 30 days. That notice of default was never sent. Without a notice of default, just as a matter of contract, they could not have ever asserted a breach of contract against my client. And from a fact basis, for all the reasons that I just asserted, there was no contractual breach by the landlord, nor could there have been, because my client complied with all of its terms, provisions, and the express written agreements between these parties when it withdrew the amounts pursuant to Exhibit 4, that ACH authorization. With respect to the fraud claim, Judge, you'll note in their complaint, it's essentially a single allegation that just says, they committed fraud. It's conclusory in its nature, and it doesn't meet all of the requirements or elements of proper pleading. And the Michigan Court of Appeals in Stevens versus Warden Insurance Agency stated very clearly that if you, as a plaintiff, fail to plead a fraud claim with particularity as required by MCR 2.112 subsection B, then it's grounds for dismissal under C8. And that's very clearly what happened here. The plaintiff's complaint doesn't specifically articulate any representation that was false or all of the other elements with respect to fraud, that the plaintiff relied upon it, that the plaintiff was somehow damaged, nor could it have been. And I would also point out that under Michigan law, and this is from In re Bradley, a state of Michigan Supreme Court case from 2013, a plaintiff can't sustain a fraud claim that.
Let me stop you for a moment, just for the court reporter. Say that case again a little bit slower, sir. You kind of zip through it, please.
It's In re Bradley Estate. It's 494 Mich 367. It's a 2013 Michigan Supreme Court case. And it stands for a pretty unremarkable proposition that in Michigan, you can't sustain a fraud claim that is essentially derivative from your breach of contract relationship. So because this allegation essentially stems from a claim of a contractual relationship, you have to have a wrong that's independent of a tort in order to sustain a fraud claim, and that isn't alleged here as a matter of law, nor has it been factually supported in any way, shape, or form. And if you eliminate the breach of contract counts and the fraud counts for either a C8 or a C10 basis, the civil conspiracy claim further follows, because you have to have a tort before you can have a conspiracy. And conversion likewise doesn't apply, both as a fact basis and a legal basis. I won't reiterate the facts, but from the law standpoint, Your Honor, when we're talking about money, Head versus Phillips Camper Sales and Rental Incorporated, that's 234 Mishap 94. That's a 1999 Court of Appeals case that addressed the concept of, can you convert money? That court specifically said that the conversion of money requires an express duty to return money that was entrusted to another's care. That's not this. This is an allegation simply that for some reason that they weren't authorized to take it, but that as a matter of fact is wrong. They authorized my client pursuant to Exhibit 4 to withdraw those funds that became due under the lease. Now, Your Honor, I will also point out that this is a C8 and a C10 motion. The defendant's motion was supported with documentary evidence, including an affidavit from Christina Rice that very specifically identifies the facts that are not in dispute. What you got in response from the plaintiff was conclusory allegations and denials. And while they did attach a quote unquote affidavit to their response, that affidavit is wholly insufficient under the law. And the reason for that, Judge, is very simple. If you look at the affidavit that was provided by Mr. Al-Bayadi, it basically says, I believe these things to have taken place. And our courts have repeatedly said that you can't make an affidavit that's going to survive a summary disposition motion upon information and belief. That's Jones versus Scheck. That's 48 Mishap 530. That's a 1973 case. And then Brooks versus Reed, 93 Mishap 166. That's a 1979 case. And I'm quoting directly from Brooks now. That court said, quote, since the supporting affidavit must be based upon the personal knowledge of the affiant, affidavits that allegations are true to the best of the affiant's knowledge and belief are generally insufficient. And that just makes sense, Your Honor. If you think about that, if we allowed a responding party to a C-10 motion to simply say, I believe these facts to be true without other evidentiary support, the court would never be permitted to grant a C-10 motion because every respondent would just simply say, here it is, Judge, and that somehow creates an issue of fact. That's not what MCR 2.116G4 contemplates. That's not what the law contemplates. And in that prism, what you've received from the plaintiff in response to our motion for summary disposition is nothing. It is literally nothing. It is just the attorney's argument that somehow our motion should be denied or that there is an issue of fact. And without evidence, without documents or affidavits, the court rules and the law compel you to grant our motion.
Well, that last statement of the court being compelled to do something is very interesting analysis in this matter. Excellent arguments, but the compelling force of the last statement is a little bit interesting. We'll consider. All right, Mrs. Aaron, where is the genuine material issue fact that is in dispute here?
Your Honor,
Let me stop you for a moment. I'm moving right at you, and I'm going to let you talk about it. It seems to me that this arises out of some language that has to do with the contracts and activities that the defendant believes that they can engage in and then bill it back, and then the contract that says that you can withdraw some money if you believe that you owe that money, and so on and so forth. So that seems the gravamen of it. So here's what I'm getting at. I'm getting at how does that turn into fraud? How does that turn into conversion? And how does that turn into a conspiracy to deprive? If we deal with the ground of this, and that is that it seems that the parties have a lease agreement. That agreement has some terms and languages in it, and the parties now have a disagreement about whether they should have been obligated to pay something, et cetera, et cetera. How does that turn into fraud and these other counts? I'm not seeing that. I want you to drill down on that and then tell me, in response to the motion, tell me what this is about. Go ahead, sir.
Your Honor, the complaint was drafted by the previous attorney, Mr. Ali Dagger. I did not draft this complaint. I took over this case about 3 months later. I did not know whether the defendant assert all those things in their affirmative defenses or not. I do not know. But what am I understanding from my client? Number one, he does not speak English. His understanding, the authorization was only to withdraw rent, not money for repair. Let's assume the money for repair is going to be withdrawn. His understanding that the repair cost $2,000. Then they withdraw $6,000 from his account. That's why he stopped it right away. When he stopped it, he filed this lawsuit. The defendant, in retaliation, they went and they filed another lawsuit against him in the Wayne County Circuit Court. So the question here, whether the amount they're withdrawing is $2,000 or $6,000, how much the amount of repair? Number one. Number two, we don't know if my client caused the damage. They just say, you caused it. This is 20 units. They have all hood. In fact, he has a bakery, and next door is bakery. All of them, they have bakery, and about 3 or 4 units, they have hood. So they accuse my client that he caused the leak. And then they send a serviceman, and when the serviceman came, he told him, well, this is going to cost $2,000. Then all of a sudden, a week later, they withdraw $6,000. And that's why, ignited the whole situation. So how much the amount of repair? The serviceman 2,000, then they took 6,000. Are they taking advantage of this gentleman because he doesn't speak English? They go and withdraw whatever amount they want because you sign a lease. His understanding to this, it's only you draw $1,500 every month is rent. Not, what about if you change the whole roof? You're gonna go to his account and take 150,000 or 20,000. Wow, well, you sign a lease. No, this is not within the understanding. So number one, he doesn't know whether he caused it. Number two, he did not authorize them to take $6,000. His understanding from the repairs, 2,000.
All right, now, let me ask you that. Obviously, so much of this is governed by the four corners of the lease agreement. And if there is language in the lease agreement that gives the defendant in this regard the right to withdraw funds where they have embarked upon repairs, et cetera, then they would have, it would seem to me that they'd have the right under this commercial lease agreement to seek payment. And if they do not receive the payment, to withdraw it, if that is in the contract. That's what I'm getting at, is whether that language is in the contract. So it sounds to me that there may very well be some issue of a dispute as to what the language of the contract allows. And so what I'm hearing, and I'm glad to know that you didn't draft this complaint, because I think that even if I take the case in a light that is utterly most favorable to the plaintiff, that it would be very, very difficult. It would strain credulity to find fraud here and to find conversion and to find those other counts that are in the complaint. And so my determination on those issues is that I just don't see where those complaints, where those counts are sustained by the nature of the complaint that is alleged here. This is a complaint that alleges a breach of contract that alleges that the contract between the parties does not allow for the taking of items from through the ACH for repairs that are done. And then there is a factual dispute that is being asserted by Mr. Zare, that factual dispute is that the claim damages and repairs that were made were not caused by the plaintiff in this matter. That seems to be what this case is about. That other stuff, there's nothing even remotely close that establishes those counts sufficiently enough for the parties or for this complaint to be able to go forward on those counts. So as it relates to the count that deals with fraud, conversion, and conspiracy, I don't find that there is any factual analysis that has been asserted herein, or that maybe even could be asserted, that would cause those counts to be sustained or even sustainable. And so I will grant the motion for summary disposition in that regard, dismissing those counts. It sounds like there.
Your Honor.
Go ahead, sir.
I think this case was filed against two defendants. The first defendants filed summary judgment, and you allowed them at that time, you granted their summary judgment and let them out, and you were thinking that this defendant should be responsible. Now today, this defendant is coming and she say, you know what, those count does not apply to us. So this complaint was against two defendants. So the first defendant is out. Now this defendant is coming. I said, oh, those are not applying to us. So this is the confusion. So it wasn't just against this defendant. The civil conspiracy, there was two defendants that you dismissed their claim.
So I think the point that you're making is that the claim of conspiracy was that Eastbourne Partners conspired with Trinity Construction to do work on the property and to overcharge Al Rana's bakery.
That's correct.
Yeah, I don't see from everything that's been alleged here. This is a claim of a breach of contract and perhaps overcharging for services. And it seems to me that you may assert that. You may assert indeed that you were overcharged, that the reasonable value of the services that were provided were not of the value that your client was charged for. You may also assert that your client is not responsible for the damages that occurred, that under the contract that somebody else was responsible, or that factually someone else caused the damage that wherein your client should not be responsible. And then secondly, of course, that and if responsible, that your client, that the amount charged is significantly more than what is reasonable. Those claims can be asserted. And then, oh, by the way, therefore, we're entitled to be remitted for the amount that was taken, either because this was somebody else's problem or because the amount charged was greater than what it should have been in this regard. But the claims of fraud and conversion and conspiracy regarding this matter, those claims have no weight here. They don't meet the standards required by C8 and C10, and for those reasons, those claims are dismissed. A reasonable argument is made regarding the breach of contract claim that seems to me to be muddled with a number of factual disputes.
Your Honor,
Go ahead, Mr. Cox.
I get the sense you're ruling, so I want to, if I can, just have.
Go ahead.
My motion, I would just like the last word if I could, Judge. I hear you and I appreciate the court's comments thus far. With respect to the breach of contract claim, though, Judge, there is no factual dispute on the record before this court. If you look at our motion and the exhibits attached, there is documentary evidence and an affidavit that says that the bakery is the one that caused the damage. That's exhibit number 8. I'm sorry, Judge, that's exhibit number 7. That exhibit is supported by exhibit number 6, which is a duly sworn affidavit from Christina Rice. You have evidence filed by the movement that supports the dismissal for no genuine issue of material fact. And what you have in response to that motion is nothing. You don't have a document, you don't have a deposition, you don't have an affidavit based on fact. You have an attorney's argument and a litigant's information and belief signed statement that isn't even notarized as required by MCR 2.119B. Those things, as we sit here today, do not constitute a basis for finding a genuine issue of material fact. And in fact, the court rules, and this is back to my comment about they compelled this court to grant the relief requested, MCR 2.116G4 specifically says, if the adverse party does not so respond, judgment shall be entered against him or her. And that's what I mean, Judge, not to say that you don't have discretion in some cases, but what you have before you compels you to grant the relief because you don't have anything more than their mere allegations and denials, and that is simply insufficient to create an issue of fact for this matter to proceed to trial.
Your Honor, if I respond.
I'm coming to you. Somehow my 30 years of serving on the bench,
Your Honor.
I know that we would come back to being compelled. And Mr. Cox, I thought that you're getting the last word. You had something new that you were going to tell me, but I see that you reiterated the last argument, which I heard very clearly the first time that you made. Mr. Zara, why does this case survive the motion for summary disposition?
Your Honor, if you look, this complaint was verified. So it's not just an affidavit. He filed a verified complaint signed by the client. So they are on the notice, not just an affidavit. He's not telling you about verified. In that verified complaint in paragraph 12, he stated that the landlord knew about the issue in the roof. And the city of Detroit fined them about $2,000 or $200, and they failed to pay it. So the building was not in compliance. So now my client, they tried to shift that damages to my client. So the issue of fact exists, whether my client caused the damages or not, my client caused the leak or not, and whether the repair was cost $2,000 or not. You can't just say, well, yeah, the lease. I said, well, he's suing my client right now for $150,000 in the Wayne County Circuit Court in front of Judge Sullivan, accusing him he's damaging the whole lease. He's accusing him that my client, accusing him that my client caused the warranty to be void. There's a lawsuit right now pending. So they go and he sued them in Wayne County. He sued them for an eviction in this court. This landlord is retaliating against this tenant left and right. I'm defending 3 or 5 lawsuits. With respect to this lawsuit, it's clearly the client said, no, I did not cause it, and the repair should not be $6,000. So this is the issue of fact. I mean, he can say whatever he wants.
Certainly, the assertions that are made by yourself as well as Mr. Cox, when you say you can say whatever you want, yeah, as long as it's rooted in law and in facts. I mean, so what Mr. Cox is seems to be alleging, you'll finally get the very last word because of this motion, is that that you have a duty to go forward once there has been an affidavit opposing the allegations that have been made with something stronger than mere allegations. And you do raise a very good point in that the complaint that the complaint is verified in this manner. And it seems to me that on its face that there is in fact a factual dispute that is going on here. Mr. Cox is saying that your client has not come forward with enough information to survive the CA nature of the motion that is asserted before the court, which usually begs for a motion to amend the complaint. But again, that's a matter of strategy that a person may want to take. So anything else, Mrs. Zaire, before I make my determination, Mr. Cox will get the last words.
Mr. Judge, I mean, I think they're not entitled to summary judgment with respect to the breach of contract. They were not authorized to take $6,000, and the issue whether they authorized or not, that's a factual question, require their motion to be denied.
Your Honor, I will add something new this time. Judge, again, I think you've identified the deficiencies in the plaintiff's response. The law, a C-10 motion is a burden shifting motion, right? We all understand that. It says that if the burden is on the non-moving party, they have to present evidence that creates the genuine issue of material fact, not the allegation or denial. And this is not me, making things up or extrapolating from case law. The Supreme Court in Quinto versus Cross and Peters Company, that's 451 Mich 358, that's a 1996 Supreme Court case, said when the burden of proof at trial would rest on the non-moving party, that's plaintiff in this case, the non-movement may not rest upon mere allegations or denials in the pleadings, but must by documentary or other evidence set forth specific facts showing that there is a genuine issue for trial. The mere fact that Mr. Al-Bayadi signed the complaint doesn't change it into an affidavit, doesn't change it into anything that's specifically factual to create a dispute. All it does is say, these are my allegations and denials in the pleadings. It's insufficient as a matter of court rule and law to overcome the burden in a C-10 motion. And again, Judge, just arguing by analogy here, if you permitted them to defeat a C-10 motion with their complaint and with a non-specific, non-personal knowledge affidavit, you would never grant a C-10 motion, because counsel would come in here on every C-10 motion and say, Judge, well, my complaint says otherwise, and my client's affidavit says I believe all of these things to be true. It just as a matter of law is insufficient to overcome their burden in this case.
Well, Your Honor, this is a district court case. He's asking about the position earlier and evidence and that. Discovery are not allowed in a district court without stipulated of the party or court order.
And you ordered it, Judge, in this case, and they did not.
That's fine, but you didn't do anything. You just waited. You've been the defendant in this case for almost a year, and now a year later you come back after you let my client spend all those time in defending this case, and now you come and you're telling the court, well, they have no case. So I do not know what your intention in this. I mean, unless you try to build your attorney fees against my client, because this is in the lease also, and that's what you're doing. You should file your motion earlier if you are correct.
Judges, as you are aware, a C10 motion is generally improper before the close of discovery. And despite Mr. Zahir's representation, you did order discovery. You ordered a lengthy discovery in this case. He chose to conduct none to support his file. That's not my problem. That's his problem. He did nothing to support his claim. That is what a C10 motion is for, to have the court make that determination today, because we don't need to waste this court's resources with a trial that is otherwise factually unsupported through all of that process.
So, all right, thank you, counsel. So I've listened to the.
Yes,
the
see, I already
arguments,
told
that they
Gaskin
made,
that I'm going out with
regard
my
to the
judge for
remaining,
lunch.
Count, which is
And
the
I
breach
can't
of
be down there
contract
for a
count,
whole
which is
hour.
really what the heart.
Judge, someone else is talking, sorry. All right.
So I've listened to the argument, and what is intuitive to this court is that this is a contractual dispute. That's what it sounds like. It's a contractual dispute that rests upon the plaintiff taking the position here that there was not a right under the contract for the ACH withdrawal. There was not a right under the contract for the termination of or instructed to make certain repairs and then to bill those repairs, and that the repairs may have been an overcharge against the plaintiff in this matter. That's really the gravamen of the claim. That's really what's being asserted here. The challenge is that those assertions are clearly set forth, if you will, in the complaint. They are attempted to be buttressed by an affidavit that was filed in response to the defendant's affidavit in his motion for summary disposition. What it takes in order to overcome, and I think I said earlier C8, but I was really talking about the C10. What it takes to overcome a C10 type of motion is an affidavit that says, for example, that the language of the contract says A, B, and C, X, Y, and Z. That the language of the contract says they can't do this. When you say that they can't make the ACH withdrawal, then you point to the contract, where in the contract it says that they cannot do that. Or you point in the contract, you make that a part of your affidavit that you were relying upon the contract that says that they can't bill for repairs that they made and then take them out ACH. And the challenge here is that once the plaintiff asserts a C10 type, the defendant asserts a C10 type motion, then it imposes an affirmative duty on the part of the plaintiff to then come forth with some additional evidence, if you will. If we assume that the verified complaint is, then it becomes necessary for you to take not only the verified complaint, but to come forward with some additional evidence to say that that affidavit that is attached to the C10 motion is invalid. It does not bear out factually. It does not bear out as it relates to the law. And here is the reason why. Because that crystallizes the case and tells this court whether or not there is enough to go forward from a factual standpoint and whether the motion should be denied in that regard. The court was on the heels of, and is still part of the court's consideration now, as to whether or not the motion should be denied as it relates to that issue, because I know from the arguments that are being made that this is a contractual dispute that got muddied by a whole bunch of other counts that were. But now, the hand of the court is being forced by whether or not the plaintiff has brought forth enough, given a C10 motion, to survive the summary disposition motion on the contract dispute. So it's a contract dispute that grew up. It grew up legally because of the fact that the plaintiff, the defendant, brought a motion saying that a motion with an affidavit attached saying that you can't that the factual allegations raised in the complaint are unsupported, and here are the reasons why. The affidavit that is filed in response to that is a mere reasserting of the claims that were raised in the verified complaint, when at this point in order to survive that motion, which is why that language of mandate and requirement that the court take certain action. That's why that language is so strong, because what that language says is that if they're not able to come forward with an affidavit or something that adds to this dispute that has grown up, that shows that there is something that is a factual dispute, then the court shall grant the motion. And that's a part of this that I'm not real crazy about, because intuitively, based upon the arguments that have been made, I know the parties have something that they disagree with. But a disagreement must grow up into a dispute that can be sustained by a factual presentation and a legal presentation where a CTM motion has been brought. The fact of the matter is, and I'm not particularly crazy about it at this point, but the fact of the matter is that Mr. Contact is be right on this point, that there is not enough that has been brought forth at this juncture that is required by law under the value of a CTM motion to survive that motion. There are mere allegations that the client, that the plaintiff believes that that there was a plot against him. He believes that there's not a right to take money on the ACH where there are repairs. He believes that those repairs or damages may have been caused by someone else. He believes that the charge for those repairs are in excess of what the charges should have been. To have an affidavit from someone asserting that the work that was done was and the charges that were made for that work was in excess of what the standard rates are, what the reasonable market rates are, that creates a dispute. That says that affidavit would say that at a minimum they overcharged me and should not have taken that much money. That would create a dispute. You had an affidavit from someone that was aware of how the damage occurred and can provide an affidavit that says that this damage occurred by virtue of these set of activities. And this is factual, and I can swear to it that it happened because of these set of activities, and that those activities are not likely to be anything related to what El Rada Bakery may have done. That creates a factual dispute, and we don't have that here. That's the kind of thing that would create a factual dispute. Although I know what the nature of the dispute is, the affidavits and the filings before the court have not ripened into a dispute that can survive the CTM motion. For that reason, the complaint, the count that relates to breach of contract, that count will be dismissed on summary disposition as well. I'll sign an order consistent with the court's determination in this matter. All right, I wish you well, gentlemen. All right, good day to you.
Thank you, Your Honor. Have a happy holiday and a happy new year.
Happy holidays. All the best. Yes, Mr. Cox, just 1 second, sir. And we're back on the Dawdale matter. There it is, back. And that's the suffix 0879, Protective Insurance Company versus Regina Dowdale and Gregory Dowdale. Counsel, welcome back, sir. And I'm looking for Miss Dowdale. Is she back? I don't see her in Zoom. Let's see.
Oh, well, she had come back, Judge. I saw her having returned. We did have a conversation.
Counsel, can you go back and show her how to get out of there?
Oh, yeah. Let me.
You know how to get back?
She's.
All right, Jefferson Capital Systems LLC under file number 22-195-344. Again, Jefferson Capital Systems LLC versus Rashana Perry. The matter is before the court set for a motion for entry of judgment. That is the matter that is before the court at this time. All right, your appearance for plaintiff at this time?
Good morning, Your Honor. Attorney Ashley Notice on behalf of plaintiff.
Your key number, if you will, Ms. Notice.
77029.
All right, thank you, Ms. Notice. Thank you for your patience as well this morning. You got to hear a very interesting motion. All right, and do I have Rashana Perry say something to me?
Yes, Rashana's here.
All right, thank you, Ms. Perry. All right, so this is a motion for entry of judgment in this matter, where there's a claim in the nature of $11,584.39. This arises out of a claim breach of an installment contract for purchase of a motor vehicle, and so it looks like the plaintiff is asking the court to go ahead and enter the judgment in this matter. Tell me what that's about, Madam Counsel, then I'll come to you, Ms. Perry.
Thank you, Your Honor. So the defendant did file a response. It wasn't a formative answer, but in her response, she admits to the contract, she admits to the debt and owing. However, she presents no resolution, just the fact that she doesn't want to be sued. Unfortunately,
I wasn't familiar with the phone. I'm looking like, what wasn't?
Ms. Dowdell, I shut you off for a moment because I was still in the hearing. I'll come right back to you in just a moment. Ms. Notice, I'm sorry. You may continue, ma'am.
It's okay. We tried to contact the defendant by phone. We haven't received any return response. So I did file my motion for judgment based on the pleadings. Per her response, again, she admits to the breach, and it seemingly wants some type of resolution, but it just presents nothing. So we would ask that judgment be entered today. And then if she does want to make payments or something to that effect, she can always contact her office and do so.
All right, and sounds like you're hacking a little bit. I hope you're feeling okay there.
Thank you.
All right. So, Ms. Perry, it seems like in this situation, when you responded or provided something in response, you're not disputing the claim. You say that you owe it. So tell me what's going on here. Go ahead, ma'am.
Oh yeah, I'm not disputing it. I just got a little behind due to COVID, lost my job, and just unemployed at the moment and couldn't get caught back up on the payments. And then I end up, about to say, the engine ended up going out on the car, so I ended up losing the car. I tried to get it fixed, and then found out I needed the engine, and then they ended up taking the car. So here we are now.
So Madam Counsel, it was repossessed, and there was some kind of was it put back in the market and some? And this
I'm
is
sorry.
What
was that, Your Honor?
Yeah, I said, I'm sorry. This is a deficiency balance here. So they repoed the car, sold it off, and then this was what was left over. Is that what it is?
Correct.
Yeah, I see where you signed this contract, and I see where the vehicle was at $24,000 plus dollars, and then you had the finance charges that took it up to $41,000. So that's why you got this kind of balance that's left. So, ma'am, I don't see where there is any kind of meaningful dispute. And typically, when these things are in court, the question becomes whether or not you have a defense to it or some reasonable dispute that can be raised. You always have the right to come to the court and ask the court partial payments, the right to set up some type of partial payment arrangement. You can also always call Ms. Nolan's office, and they'll talk about setting up some type of payment plan if you want to attack it that way. I understand at this point you were saying that you're not employed, but even if you're not employed, that still doesn't stop the plaintiff from being able to pursue their right to entry of a judgment. The only thing that would kind of stop that is if you had something filed in bankruptcy or something like that. You don't have a bankruptcy petition.
No, I'm inquiring on that now.
Okay. All right. So I don't, and if that happens, what the bankruptcy does is it stops everything that goes on here. It stops the ability to collect or anything else if you file bankruptcy on a claim. All right. So it seems to me that under these circumstances where the plaintiff has filed a motion for entry of judgment, where there's no dispute as to the amount that is owed and that there is a breach of contract here, I will enter the judgment on the terms as prayed in the complaint. And so judgment will be entered in this matter. The total amount is $11,887.23. Now, again, after 21 days, the plaintiff can begin to try and collect on that judgment. If the defendant wants to file a petition to get partial payments or want to set up some type of payment arrangement, she can either call Ms. Nolan's office or she can file a petition with the court, and the court will consider your desire for a plan to pay this on a monthly or bi-monthly basis. All right. So I'm signing the order. You'll get a copy of it, Ms. Perry, and Ms. and that account will get a copy as well. I wish the best to all that's involved. Happy holidays.
Thank you. Same to you, Your Honor.
Thank you. Ugh.
All right, and back on the record again on 0879, that is Protective Insurance Company versus Gregory Daldale. I do have the application for entry of default regarding Daldale, given that he's been served and is not present in this matter. But go ahead. I see Ms. Perry. That's right there. I see Ms. Daldale that's back. Welcome back, Ms. Daldale. And I see counsel that's back, Mr. Cox. Mr. Cox, thank you for assisting getting Ms. Daldale back in. Update me on this matter, if you will, sir.
Well, Judge, I think the crux of the case turns on the issue of whether the defendant who had a Liberty Mutual Insurance auto policy on the date of loss, where that policy is actually going to be in effect. My client's being told that the insurance policy was not in effect on the basis of an unauthorized driver. Ms. Dowdell said that they actually did process a claim but didn't pay out because they didn't believe the facts of the case with regards to the damages. So I think Ms. Dowdell did have the name and telephone number of an adjuster with Liberty Mutual, and my intention is to contact them. I've advised her that she should probably do the same. And so what I'm seeking to do is confirm what we believe to be true, which is that there's not active coverage for this loss on her end. And if that's the case, we would continue to proceed against her as owner of the vehicle. So I guess what I would like is a bit of time to conduct that investigation or confirmation of what we believe to be true. I've also told Ms. Dowdell that I will send her the documentation I have in my claim file that pertains to our investigation in her own insurance. But yes, Judge, we do show service as to Gregory. He's not here. I guess we would ask that judgment entered against him for his non-appearance. Ms. Dowdell did tell me that she said she was served at the address we have listed for him. But we have a process server that's attesting the fact that he served him at that address.
And it sounds like to me that Ms. Dowdell, and you tell me if this is true, Ms. Dowdell, you're saying that you want to go, you're submitting to the court's jurisdiction. You want this matter to be determined in this hearing, and not following your paperwork. You are submitting to the court deciding this case. Is that what you're saying?
She's muted.
You gotta come off of mute to talk to me. Hit your star 8 or whatever it is. Star 6. Whatever the microphone is on your phone, you got to go ahead and tap that so you can talk to me. Come on, you can do it. You did it before.
I don't think she heard you, Judge, with the star 6.
Wow. Yeah, try the star 6. Try hitting star 6 on your phone. That may help you to get back on. I can't hear you because you're still on mute. You know how to come off mute? Yeah, well, I think adjourning it is the right thing to do. And I'll stand down on entering the default at this time, but the
Okay.
default application is there. So
Okay.
I'm gonna go ahead. My inclination, I'm looking into the week of February 21st, because that's 60 days out. So I will be looking at maybe the 22nd of February as the next action date in this matter. And that'll give time to iron out all those issues. Before we make
Is
this
there a
determination.
time on the 22nd, Your Honor?
Yeah, that would be at 9:45. 2/22/23 at 9:45.
So February 22nd, 2023 at 9:45.
Yes, and
Okay.
Ms. Dowdell, that's a new date. And we're gonna come back on February 22nd, 2023. I'm gonna send you a notice in the mail. That notice is gonna have that date on 9:45 a.m. You'll get a new court date at 9:45.
Ms. Dowdell did confirm that the Garfield address was good for her. So that remains where she needs that sent.
Which address? On what street?
The one that we show on the summons, the Garfield address. She told me in the breakout room that was an accurate, that was still a good address for her, the 13950 Garfield in Redford.
Okay, got it. All right, we'll make sure that the new date comes out to Ms. Dowdell on Garfield Street. We'll make sure that it gets on that. I wish I could hear you, Ms. Dowdell, but you're on mute. You're still on mute, ma'am. You gotta come off mute so I can hear you. *6 will get you off mute. You said you tried that. I heard that. Okay, I can see that. Do you have a microphone symbol on your phone, on your device, a microphone symbol? That'll get you off mute.
On mine, you have to tap the screen. And when you tap the screen, then the microphone appears.
Maybe all you need to do is tap your screen. Try tapping your screen.
And then at the bottom, is there a microphone that shows up?
Does a microphone come up when you tap the screen?
No.
All right, so I'm gonna get some paperwork out to you for the next date, ma'am. So you make sure you be here in February. All right, thank you, counsel. Good day.
Have a good holiday, Judge. Thank you. Appreciate your patience.
Good day to you, Ms. Dowdell. Now, counsel, when you send this one out, make sure, I'm gonna go ahead and leave that open because it's two addresses, but you want to send Ms. Dowdell's to that.
Okay.
Okay. And I put the tab with the date on it. All right, I do have, case number 07101-461. That's asset acceptance versus Georgetta Michael. The matters before the court. Looks like an adjourned date of hearing on a motion for installment, strike that, a motion objecting to a writ of garnishment. And that writ of garnishment as the Charles Wright African American Museum. And I did receive objections to the same, but I also received a certificate of satisfied judgment. So the motion in this matter, or I should say the objections, are granted and the satisfaction of judgment is signed in this matter. And that will close this case up. case number 21-165-479. Looks like there is a satisfaction in the file on this matter, so that matter should close out because there is satisfaction.